make some laws abridging freedom of the press?
No, sir. Only in that I have conceded for purposes of this argument that some limitation, some impairment of the absoluteness of that prohibition is possible. And I argue that whatever that may be, it is surely at its very least when the president acts without statutory authority, because that inserts into it as well a separate power.
It's an argument for the Times to be making. The Congress can make all this illegal by passing laws.
Well, I didn't really argue that, Mr. Justice.
That was the wrong impression you left in my mind.
Apply to the Chief Justice on a case that arose without a statute, and try to distinguish, because it's crucial for purposes of this case to distinguish between the authority which is here claimed of the president to act independently without a statute, and the possibly greater authority of the whole government through the machinery of legislation to act in similar premises, which I can see nothing that I don't have, Mr. Justice.
What's all this about a statute and separation of powers? Anyway, the idea that Bickel is espousing here is that to allow the president, the executive branch, to prevent the press from publishing in its inherent power violates the separation of powers and powers among the three branches of government with the checks and balances between them. What's missing here, Bickel is pointing out, is a statute authorizing the executive branch, the president, the Department of Defense, to get this kind of relief, to get this extraordinary kind of relief, a prior restraint. The People's Branch, the Congress, has not acted. Yes, they have this espionage law, but that's only criminal penalties for having spied and sold government secrets and so on. That results in, after the fact, subsequent punishment. It doesn't authorize a prior restraint. And the notion that Bickel is planting here is that it's a power grab by the president, by the executive branch, without any authorization from the Congress, and the standard should be different, Bickel is saying, in this kind of a situation, than if Congress had acted. That's all there is to that. Now, Griswold gets rebuttal time, as any lawyer does who argues first. He gets to go last. And this is rebuttal.
12 minutes, thereabouts left.
Mr. Chief Justice, and may it please the Court, I should like to make it plain that we are not at all concerned with past events in this case. We are not interested in protecting anybody. That should be obvious enough simply from the date of the materials which are involved. We are concerned with the present and future impact of the publication of some of this material. And when I say future, I don't mean in the 21st century, but I also don't mean to limit it to tomorrow. Because in this area, events of great consequence to the United States happen over periods of 6 months, a year, perhaps 2 or 3 years. But what we are concerned with is the impact on the present and the reasonably near future of the publication of these events, of these materials. Now, it is perfectly true that prior restraint cases with respect to the press are rare or conceivably non-existent. I'm not ready to concede that they're non-existent, but I can't point to one.
Mr. General, what particularly worries me at this point is I assume that there are not studies now being made in the future. There will be studies made about Cambodia, Laos, you name it. And if you prevail in this case, then in any instance that anybody comes about any of those studies, a temporary restraining order will automatically issue. Am I correct?
It's hard for me to answer the question in such broad terms. I think that if properly classified materials are improperly acquired, and that it can be shown that they do have an immediate or current impact on the security of the United States, that there ought to be an injunction. Now, I think it is relevant at this point.
But wouldn't we then be, the federal courts being the censorship board?
That's a pejorative way to put it, Mr. Justice. I don't know what the alternative is.
The First Amendment.
Yes, Mr. Justice, and we are, of course, fully supporting the First Amendment. The problem in this case is the construction of the First Amendment. Now, Mr. Justice Black, your construction of that is well known, and I certainly respect it. You say that no law means no law, and that should be obvious. And I can only say, Mr. Justice, that to me it is equally obvious that no law does not mean no law, and I would seek to persuade the Court that that is true. As Chief Justice Marshall said so long ago, it is a Constitution we are interpreting. All we ask for here is the construction of the Constitution in the light of the fact that it is a part of the Constitution, and that there are other parts of the Constitution which grant powers and responsibilities to the executive, and that the First Amendment was not intended to make it impossible for the executive to function or to protect the security of the United States.
Well, that's the basic argument. The Court then went into recess. Case is under submission. They went back to their conference and voted on how this case should be resolved. They voted 6-3, with Berger, Blackman, and Harlan dissenting. Because the Court was right at the end of their term, because of the urgent need to get the case decided, the Court aborted its normal opinion writing process. Instead, the Chief Justice here was in the minority. He wouldn't have signed a majority opinion anyway. Instead of there being an opinion for the Court, a majority opinion, and a dissent, each justice went back to his own chambers and wrote an opinion. So what we end up with are 9 separate opinions, one for each justice. And the decision, as recorded, you see in the reader, starts with a per curiam by the Court disposition of the case, in which, it's unsigned, it just says per curiam, any system of prior restraints of expression comes to this Court bearing a heavy presumption against its constitutional validity, citing as precedent Neer versus Minnesota. The government, thus, the imposition of such a restraint concludes the government has not met that burden. And then each justice goes off and writes his own opinion. And Black, joined by Douglas, take the absolutist position that you would expect, dismissing the idea that the government would ever be entitled to an injunction prohibiting the press from publishing information in its hands. Justice Brennan concurring, saying that all we've been getting here from the government is that the material publication ought to be enjoined because it could, its disclosure could, or might, or may prejudice the national interest in various ways, but the First Amendment tolerates absolutely no prior judicial restraints of the press predicated upon surmise or conjecture. And dragging up Chief Justice Hughes' statement in Neer, the chief purpose of the First Amendment's guarantee of freedom of press is to prevent prior restraints upon publication. Then you get to the justices in the middle. Stewart, joined by White, says they are convinced that the executive branch is correct with respect to some of these documents, but they cannot say that disclosure of any of them will surely result in direct, immediate, and irreparable damage to our nation or its people. White joins in that. He's also convinced that revelation of some of these documents will do substantial damage to public interests, but the government hasn't satisfied its burden of proof. And then Chief Justice Berger dissents, basically on the grounds that this is really not fair to us to have to decide a case of such moment, of such consequence, in such a hurry, where we don't know the facts and we don't even know if anybody knows all of the facts here. Why are we in this posture, he says? These cases have been conducted in unseemly haste. We should take our time, the court should take our time, get to the bottom of this and make a deliberate, informed decision on the facts when they're all out. The problem with that is this. If it is true, as the per curiam opinion says, as is well accepted and settled in prior restraint cases, if it is true that there is a presumption, the court even calls it a heavy presumption, if there is a presumption against the validity of any prior restraint, then if you don't know what the facts are, who wins? The government can't win if you don't know what the facts are, because they have to overcome the presumption that you can't have a prior restraint. They have to put on evidence and carry the burden of showing that they're entitled to a prior restraint. And if you don't know what the facts are, they haven't done that. That seems to me the answer to the Chief Justice's point. Justice Harlan, as usual, thoughtfully dissents, and he says there are a number of questions that really needed to be answered here and haven't been. Once again, he's troubled by the fact that they don't know the facts and they're having to go too fast. And Harlan's saying the court can't ignore the fact that the papers were stolen. That's got to be more than relevant. Somebody here has engaged in criminal behavior, and that got to weigh on the scales in deciding whether a prior restraint is possible. Remember that at the time the court is deciding the case, they don't know anything about Ellsberg. They don't know how the papers got to the newspapers. They don't have a clue. I mean, internally in the government, Ellsberg was definitely a suspect, but they didn't have any case against him then, and the justices didn't know who had gotten the paper. But it was clear that someone had acted wrongfully in disclosing the papers to the Times. What's the relevance of that? Harlan also wants the question answered, what's the relevance, what's the weight we should give to the opinion of high executive branch officials, the brass in the Pentagon, who are, after all, in charge of our national security, and they're rendering opinions in this case, expert opinions, saying that publication of this material will seriously harm the national security. Should we ignore those opinions? Say, well, they're not convincing enough for us? That's a legitimate question that Harlan thought should be answered, but wasn't. And then he said, what's the relevance of the fact that the Times had the Pentagon Papers for several months before going with publication? Several months. Why shouldn't the court be able to delay publication for several months? That's basically the point that Bickel argued before the district judge. Respectfully saying, it's none of your business, Judge. That's the press's choice, constitutionally, not the court's choice. Well, 25 years after the decision in the Pentagon Papers case, Erwin Griswold, the Solicitor General, no longer Solicitor General, wrote an op-ed piece in the New York Times remembering the events of those 2 weeks and the decision, and concluding that there has never been a shred of evidence of damage to the national security as a result of the publication of the Pentagon Papers. There just never was one. Which reminds us that in the very nature of things, a prior restraint is based on a prediction that harm will befall us if publication happens. I think we should stop here. There's a follow-up case to the Pentagon Papers, the Progressive case, which makes it clear what the standard is for prior restraints and so on. We'll finish up with that quickly on Tuesday and then go on to more national security stuff and the WikiLeaks phenomenon.